Utilitarianism, Chapter 5. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Utilitarianism by John Stuart Mill. Chapter 5. On the connection between justice and utility. Part 1. In all ages of speculation, one of the strongest obstacles to the reception of the doctrine that utility, or happiness, is the criterion of right and wrong, has been drawn from the idea of justice. The powerful sentiment and apparently clear perception, which that word recalls with a rapidity and certainty resembling an instinct, have seemed to the majority of thinkers to point to an inherent quality in things, to show that the just must have an existence in nature as something absolute, generically distinct from every variety of the expedient, and, in idea, opposed to it, though, as is commonly acknowledged, never in the long run disjoined from it in fact. In the case of this, as of our other moral sentiments, there is no necessary connection between the question of its origin and that of its binding force. That a feeling is bestowed on us by nature does not necessarily legitimate all its promptings. The feeling of justice might be a peculiar instinct, and might yet require, like our other instincts, to be controlled and enlightened by a higher reason. If we have intellectual instincts leading us to judge in a particular way, as well as animal instincts that prompt us to act in a particular way, there is no necessity that the former should be more infallible in their sphere than the latter in theirs. It may as well happen that wrong judgments are occasionally suggested by those, as wrong actions by these. But though it is one thing to believe that we have natural feelings of justice, and another to acknowledge them as an ultimate criterion of conduct, these two opinions are very closely connected in point of fact. Mankind are always predisposed to believe that any subjective feeling, not otherwise accounted for, is a revelation of some objective reality. A present object is to determine whether the reality to which the feeling of justice corresponds is one which needs any such special revelation, whether the justice or injustice of an action is a thing intrinsically peculiar and distinct from all its other qualities, or only a combination of certain of those qualities presented under a peculiar aspect. For the purpose of this inquiry, it is practically important to consider whether the feeling itself of justice and injustice is sui generis, like our sensations of color and taste, or a derivative feeling formed by a combination of others. And this it is the more essential to examine, as people are, in general, willing enough to allow that objectively the dictates of justice coincide with a part of the field of general expediency, but inasmuch as the subjective mental feeling of justice is different from that which commonly attaches to simple expediency, and, except in the extreme cases of the latter, is far more imperative in its demands, people find it difficult to see in justice only a particular kind or branch of general utility, and think that its superior binding force requires a totally different origin. To throw light upon this question, it is necessary to attempt to ascertain what is the distinguishing character of justice or of injustice, what is the quality, or whether there is any quality, attributed in common to all modes of conduct designated as unjust, for justice, like many other moral attributes, is best defined by its opposite, and distinguishing them from such modes of conduct as are disapproved, but without having that particular epithet of disapprobation applied to them. If in everything which men are accustomed to characterize as just or unjust, some one common attribute or collection of attributes is always present, we may judge whether this particular attribute or combination of attributes would be capable of gathering round it a sentiment of that peculiar character and intensity by virtue of the general laws of our emotional constitution, or whether the sentiment is inexplicable and requires to be regarded as a special provision of nature. If we find the former to be the case, we shall, in resolving this question, have resolved also the main problem. If the latter, we shall have to seek for some other mode of investigating it. To find the common attributes of a variety of objects, it is necessary to begin by surveying the objects themselves in the concrete. Let us therefore advert successively to the various modes of action and arrangements of human affairs which are classed, by universal or widely spread opinion, as just or as unjust. The things well known to excite the sentiments associated with those names are of a very multifarious character. I shall pass them rapidly in review, without studying any particular arrangement. In the first place, it is mostly considered unjust to deprive anyone of his personal liberty, his property, or any other thing which belongs to him by law. Here, therefore, is one instance of the application of the terms just and unjust in a perfectly definite sense, namely, that it is just to respect, unjust to violate, the legal rights of anyone. But this judgment admits of several exceptions, arising from the other forms in which the notion of justice and injustice present themselves. For example, the person who suffers the deprivation may, as the phrase is, have forfeited the rights which he is so deprived of, a case to which we shall return presently. But also, secondly, the legal rights of which he is deprived may be rights which ought not to have belonged to him. In other words, the law which confers on him these rights may be a bad law. When it is so, or when, which is the same thing for our purpose, it is supposed to be so, opinions will differ as to the justice or injustice of infringing it. Some maintain that no law, however bad, ought to be disobeyed by an individual citizen, that his opposition to it, if shown at all, should only be shown in endeavoring to get it altered by competent authority. This opinion, which condemns many of the most illustrious benefactors of mankind, and would often protect pernicious institutions against the only weapons which, in the state of things existing at the time, have any chance of succeeding against them, is defended by those who hold it on grounds of expediency, principally on that of the importance to the common interest of mankind of maintaining inviolate the sentiment of submission to law. Other persons, again, hold the directly contrary opinion, that any law judged to be bad may blamelessly be disobeyed, even though it be not judged to be unjust, but only inexpedient, while others would confine the license of disobedience to the case of unjust laws. But again, some say that all laws which are inexpedient are unjust, since every law imposes some restriction on the natural liberty of mankind, which restriction is an injustice unless legitimated by tending to their good. Among these diversities of opinion, it seems to be universally admitted that there may be unjust laws, and that law, consequently, is not the ultimate criterion of justice, but may give to one person a benefit or impose on another an evil, which justice condemns. When, however, a law is thought to be unjust, it seems always to be regarded as being so in the same way in which a breach of law is unjust, namely, by infringing somebody's right, which, as it cannot in this case be a legal right, receives a different appellation, and is called a moral right. We may say, therefore, that a second case of injustice consists in taking or withholding from any person that to which he has a moral right. Thirdly, it is universally considered just that each person should obtain that, whether good or evil, which he deserves, and unjust that he should obtain a good or be made to undergo an evil which he does not deserve. This is, perhaps, the clearest and most emphatic form in which the idea of justice is conceived by the general mind. As it invokes the notion of desert, the question arises, what constitutes desert? Speaking in a general way, a person is understood to deserve good if he does right, evil if he does wrong, and in a more particular sense, to deserve good from those to whom he does or has done good, and evil from those to whom he does or has done evil. The precept of returning good for evil has never been regarded as a case of the fulfillment of justice, but as one in which the claims of justice are waived in obedience to other considerations. Fourthly, it is confessedly unjust to break faith with anyone, to violate an engagement, either express or implied, or disappoint expectations raised by our own conduct, at least if we have raised those expectations knowingly and voluntarily. Like the other obligations of justice already spoken of, this one is not regarded as absolute, but is capable of being overruled by a stronger obligation of justice on the other side, or by such conduct on the part of the person concerned as is deemed to absolve us from our obligation to him, and to constitute a forfeiture of the benefit which he has been led to expect. Fifthly, it is, by universal admission, inconsistent with justice to be partial, to show favor or preference to one person over another in matters to which favor and preference do not properly apply. Impartiality, however, does not seem to be regarded as a duty in itself, but rather as instrumental to some other duty. For it is admitted that favor and preference are not always censurable, and, indeed, the cases in which they are condemned are rather the exception than the rule. A person would be more likely to be blamed than applauded for giving his family or friends no superiority in good offices over strangers, when he could do so without violating any other duty. And no one thinks it unjust to seek one person in preference to another as a friend, connection, or companion. Impartiality, where rights are concerned, is of course obligatory, but this is involved in the more general obligation of giving to everyone his right. A tribunal, for example, must be impartial, because it is bound to award, without regard to any other consideration, a disputed object to the one of two parties who has the right to it. There are other cases in which impartiality means being solely influenced by desert, as with those who, in the capacity of judges, preceptors, or parents, administer reward and punishment as such. There are cases, again, in which it means being solely influenced by consideration for the public interest, as in making a selection among candidates for a government employment. Impartiality, in short, as an obligation of justice, may be said to mean being exclusively influenced by the considerations which it is supposed ought to influence the particular case in hand, and resisting solicitation of any motives which prompt to conduct different from what those considerations would dictate. Nearly allied to the idea of impartiality is that of equality, which often enters as a component part both into the conception of justice and into the practice of it, and, in the eyes of many persons, constitutes its essence. But in this, still more than any other case, the notion of justice varies in different persons, and always conforms, in its variations, to their notion of utility. Each person maintains that equality is the dictate of justice, except where he thinks that expediency requires inequality. The justice of giving equal protection to the rights of all is maintained by those who support the most outrageous inequality in the rights themselves. Even in slave countries, it is theoretically admitted that the rights of the slave, such as they are, ought to be as sacred as those of the master, and that a tribunal which fails to enforce them with equal strictness is wanting in justice, while, at the same time, institutions which leave to the slave scarcely any rights to enforce are not deemed unjust, because they are not deemed inexpedient. Those who think that utility requires distinctions of rank do not consider it unjust that riches and social privileges should be unequally dispensed, but those who think this inequality inexpedient think it unjust also. Whoever thinks that government is necessary sees no injustice in as much inequality as is constituted by giving to the magistrate powers not granted to other people. Even among those who hold leveling doctrines, there are differences of opinion about expediency. Some communists consider it unjust that the produce of the labor of the community should be shared on any other principle than that of exact equality. Others think it just that those should receive most whose wants are greatest, while others hold that those who work harder, or who produce more, or whose services are more valuable to the community, may justly claim a larger quota in the division of the produce. And the sense of natural justice may be plausibly appealed to in behalf of every one of these opinions. Among so many diverse applications of the term justice, which yet is not regarded as ambiguous, it is a matter of some difficulty to seize the mental link which holds them together, and on which the moral sentiment adhering to the term essentially depends. Perhaps in this embarrassment some help may be derived from the history of the word, as indicated by its etymology. In most, if not in all languages, the etymology of the word, which corresponds to just, points distinctly to an origin connected with the ordinances of law. Justum is a form of jusum, that which has been ordered. Dikaion comes directly from dike, a suit at law. Recht, from which came right and righteous, is synonymous with law. The courts of justice, the administration of justice, are the courts and the administration of law. La justice, in French, is the established term for judicature. I am not committing the fallacy, imputed with some show of truth to Horn Tooke, of assuming that a word must still continue to mean what it originally meant. Etymology is slight evidence of what the idea now signified is, but the very best evidence of how it sprang up. There can, I think, be no doubt that the idée mère, the primitive element in the formation of the notion of justice, was conformity to law. It constituted the entire idea among the Hebrews, up to the birth of Christianity, as might be expected in the case of a people whose laws attempted to embrace all subjects on which precepts were required, and who believed those laws to be a direct emanation from the Supreme Being. But other nations, and in particular the Greeks and Romans, who knew that their laws had been made originally and still continued to be made by men, were not afraid to admit that those men might make bad laws, might do by law the same things and from the same motives, which if done by individuals without the sanction of law would be called unjust. And hence a sentiment of injustice came to be attached, not to all violations of law, but only to violations of such laws as ought to exist, including such as ought to exist but do not, and to laws themselves, if supposed to be contrary to what ought to be law. In this manner, the idea of law and of its injunctions was still predominant in the notion of justice, even when the laws actually in force cease to be accepted as the standard of it. It is true that mankind consider the idea of justice and its obligations as applicable to many things which neither are, nor it is desired that they should be, regulated by law. Nobody desires that laws should interfere with a whole detail of private life. Yet everyone allows that in all daily conduct a person may and does show himself to be either just or unjust. But even here, the idea of the breach of what ought to be law still lingers in a modified shape. It would always give us pleasure, and chime in with our feelings of fitness, that acts which we deem unjust should be punished, though we do not always think it expedient that this should be done by the tribunals. We forego that gratification on account of incidental inconveniences. We should be glad to see just conduct enforced and injustice repressed, even in the minutest details, if we were not, with reason, afraid of trusting the magistrate with so unlimited an amount of power over individuals. When we think that a person is bound in justice to do a thing, it is an ordinary form of language to say that he ought to be compelled to do it. We should be gratified to see the obligation enforced by anybody who had the power. If we see that its enforcement by law would be inexpedient, we lament the impossibility. We consider the impunity given to injustice as an evil, and strive to make amends for it by bringing a strong expression of our own and the public disapprobation to bear upon the offender. Thus the idea of legal constraint is still the generating idea of the notion of justice, though undergoing several transformations before that notion as it exists in an advanced state of society becomes complete. The above is, I think, a true account, as far as it goes, of the origin and progressive growth of the idea of justice. But we must observe that it contains as yet nothing to distinguish that obligation from moral obligation in general. For the truth is that the idea of penal sanction, which is the essence of law, enters not only into the conception of injustice, but into that of any kind of wrong. We do not call anything wrong unless we mean to imply that a person ought to be punished in some way or other for doing it. If not by law, by the opinion of his fellow creatures; if not by opinion, by the reproaches of his own conscience. This seems the real turning point of the distinction between morality and simple expediency. It is a part of the notion of duty in every one of its forms that a person may rightfully be compelled to fulfill it. Duty is a thing which may be exacted from a person, as one exacts a debt. Unless we think that it may be exacted from him, we do not call it his duty. Reasons of prudence, or the interest of other people, may militate against actually exacting it, but the person himself, it is clearly understood, would not be entitled to complain. There are other things, on the contrary, which we wish that people should do, which we like or admire them for doing, perhaps dislike or despise them for not doing, but yet admit that they are not bound to do. It is not a case of moral obligation. We do not blame them, that is, we do not think that they are proper objects of punishment. How we come by these ideas of deserving and not deserving punishment will appear, perhaps, in the sequel. But I think there is no doubt that this distinction lies at the bottom of the notions of right and wrong, that we call any conduct wrong or employ instead some other term of dislike or disparagement, according as we think that the person ought or ought not to be punished for it. And we say it would be right to do so and so, or merely that it would be desirable or laudable, according as we would wish to see the person whom it concerns compelled or only persuaded and exhorted, to act in that manner. Footnote. See this point enforced and illustrated by Professor Bain in an admirable chapter entitled The Ethical Emotions, or the Moral Sense, of the second of the two treatises composing his elaborate and profound work on the mind. End footnote. This, therefore, being the characteristic difference which marks off, not justice, but morality in general, from the remaining provinces of expediency and worthiness, the character is still to be sought which distinguishes justice from other branches of morality. Now, it is known that ethical writers divide moral duties into two classes, denoted by the ill-chosen expressions, duties of perfect and of imperfect obligation, the latter being those in which, though the act is obligatory, the particular occasions of performing it are left to our choice, as in the case of charity or beneficence, which we are indeed bound to practice, but not toward any definite person, nor at any prescribed time. In the more precise language of philosophic jurists, duties of perfect obligation are those duties in virtue of which a correlative right resides in some person or persons. Duties of imperfect obligation are those moral obligations which do not give birth to any right. I think it will be found that this distinction exactly coincides with that which exists between justice and the other obligations of morality. In our survey of the various popular acceptations of justice, the term appeared generally to involve the idea of a personal right, a claim on the part of one or more individuals, like that which the law gives when it confers a proprietary or other legal right. Whether the injustice consists in depriving a person of a possession, or in breaking faith with him, or in treating him worse than he deserves, or worse than other people who have no greater claims, in each case the supposition implies two things: a wrong done, and some assignable person who is wronged. Injustice may also be done by treating a person better than others, but the wrong in this case is to his competitors, who are also assignable persons. It seems to me that this feature in the case, a right in some person, correlative to the moral obligation, constitutes the specific difference between justice and generosity or beneficence. Justice implies something which it is not only right to do and wrong not to do, but which some individual person can claim from us as his moral right. No one has a moral right to our generosity or beneficence, because we are not morally bound to practice those virtues towards any given individual. And it will be found with respect to this, as to every correct definition, that the instances which seem to conflict with it are those which most confirm it. For if a moralist attempts, as some have done, to make out that mankind generally, though not any given individual, have a right to all the good we can do them, he at once, by that thesis, includes generosity and beneficence within the category of justice. He is obliged to say that our utmost exertions are due to our fellow creatures, thus assimilating them to a debt, or that nothing less can be a sufficient return for what society does for us, thus classing the case as one of gratitude, both of which are acknowledged cases of justice. Wherever there is right, the case is one of justice, and not of the virtue of beneficence. And whoever does not place the distinction between justice and morality in general, where we have now placed it, will be found to make no distinction between them at all, but to merge all morality in justice. Having thus endeavored to determine the distinctive elements which enter into the composition of the idea of justice, we are ready to enter on the inquiry whether the feeling which accompanies the idea is attached to it by a special dispensation of nature, or whether it could have grown up, by any known laws, out of the idea itself, and, in particular, whether it can have originated in considerations of general expediency. Part 1, Chapter 5. This recording is in the public domain.